Good afternoon, sir. Can you see and hear us?
Yes, I can. Thank you.
Thank you very much. Just before we start, and good afternoon, Mr. Jackson, 2 points of correction or clarification. Firstly, I think I suggested that an email of the 19th of December from Herbert Smith Freehills was sent in the evening. It was in fact sent at about 9 a.m. in the morning. It was one of the early ones. And secondly, I suggested that we hadn't heard proposals from you on remediation of Phase 6 searches. I'm told that, in fact, although there wasn't a letter, there was an email from an associate at your firm saying essentially what you told us today, that it's not currently assessed by Post Office, that remediation is necessary because of the timing and content of the Rule 9 and Section 21 notices relating to Phase 6.
Yes, I was aware of that exchange between our colleagues, yes.
Thank you very much. Just to complete the Stephen Bradshaw run of correspondence, I think we had reached the Friday before he was due to give evidence. Can we look lastly, please, at, penultimately, please, at poll 0033 3345. This is an email sent Wednesday this week at 11 o'clock in the morning from Herbert Smith Freehills to the inquiry. Peters & Peters are assisting the Post Office with the review of documents relating to Stephen Bradshaw. So this is the day before he gives evidence. We refer to the note prepared by Peters & Peters, which was provided to the inquiry on Friday, that's where we left off, regarding the 942 documents produced to the inquiry that same day. In that note, Peters & Peters explained that as part of the Post Office's efforts to identify duplicative material to the inquiry, KPMG had run a duplicate analysis over those 942 documents. Of the 942 documents, KPMG identified 420 as being MD5 hash duplicates, or 98 to 100% textual near duplicates, TNDs, of documents previously produced to the inquiry. However, Peters & Peters believed that a substantial number of the remaining 522, in inverted commas, new documents also appeared to be textual near duplicates of documents previously produced to the inquiry. These included record of taped interviews and investigation reports from question 42 of Rule 914 cases, which have been produced to the inquiry on multiple occasions. KPMG therefore investigated why those documents were not identified as part of its original duplicates analysis. Conclusion was these documents were not flagged as textual near duplicates because they fell below the requested textual similarity threshold of 98%. KPMG explained that whilst documents Peters & Peters had highlighted appear to be textually similar, small variations may have caused the documents to fall below the 98% similarity threshold. KPMG therefore broadened its analysis from 98 to 99% to 90 to 99%. The results of that broader analysis indicated 578 documents in the production were duplicates of documents previously produced to the inquiry. KPMG's most recent analysis indicates that Friday's production contains 364 new documents. This remains contrary to the feedback from Peters & Peters' review team, who have indicated that a very large volume of the material from Friday's production was duplicative of documents previously produced to the inquiry. Peters & Peters has therefore begun a further manual review of the 364 new documents to determine whether on their face they appear similar to the material previously produced to the inquiry. It's apparent from the preliminary findings of that manual review there is still textual near duplicates of previously produced material within the 364 new documents. For example, Peters & Peters has sent multiple legal memos regarding Huey Thomas's court hearings, Huey Thomas's mediation application and mediation report, and multiple copies of Huey Thomas audit report, all of which have been produced to the inquiry previously. Post Office has asked KPMG to investigate these examples urgently to understand why these documents have not been caught. In parallel, Peters & Peters is conducting a full manual review of the 364 new documents from Friday's production. Following further investigation, KPMG has been able to confirm that the additional examples were not identified as textual near duplicates, as the duplicates previously produced to the inquiry were produced by another firm and transferred to KPMG. Post Office understands that these duplicates contain junk characters at the end of the extracted text file, causing them to have significant textual variations from the documents in Friday's Bradshaw-related production. Even though it appears that several of the items within the new 364 documents have been produced to the inquiry as many as 5 times before, they've not been picked up in KPMG's duplicate analysis. This may explain why KPMG's analysis does not correspond with Peters & Peters' view that the new documents contain numerous duplicates. In addition, the Post Office understands from KPMG that textual near duplication analysis is often not effective when analysing Excel files. This might further explain why potential duplicates have not been picked up. As the Post Office's further investigations will take time to complete, the Post Office arranged for a new overlay to Friday's production, prepared by KPMG, to be uploaded to egress, so the inquiry can see which documents have been identified as duplicates. However, the Post Office will endeavour to update the inquiry on the results. So this is all the day before a witness who'd been adjourned for over a month to give evidence, was due to give evidence.
Yes.
Your firm's not responsible for any of this.
No.
But you're here to speak, I think, to the Post Office's disclosure to the inquiry, including in phases 4 and following.
I can't speak as to phase 4. Prior to the 1st of December, when I submitted my witness statement, the exchange that we had with the inquiry was said I would endeavour to draw together the threads, I think, as I put it, that I would set out what I could answer to and that which I could not, and the inquiry would effectively come back to us if you wanted to hear from anyone else. Now, obviously, in timing, this is recent, so that could not have been picked up, but I can't answer to operational detail of phase 4, not because I wouldn't wish to, but simply because I don't have the knowledge to do that.
The last document in the train of documents is a note received either whilst Mr. Bradshaw was giving evidence or after he gave evidence yesterday from Peters & Peters, which said that the additional checks that were undertaken in respect of Mr. Bradshaw's Mimecast data were as following, and that the Post Office understands from Peters & Peters that none of the potentially new documents produced to the inquiry on the 5th of January contained any materially new information. Do you know anything about those two things?
No, the only thing I'm aware of in relation to that note was I understand that in an attempt to drive some of the numbers of duplicates or near duplicates down, a degree of controlled item level deduplication was done after the production stage, so at a sort of safe stage of it. That's the only thing I'm aware of, because KPMG updated me on it. I'm
interested in particular in the suggestion that this was material obtained from Mimecast, whereas this should all be about Exchange 365.
I simply don't know. I'm sorry.
I mean, Mimecast is the thing that ought to have been interrogated months, if not years ago.
Mimecast has been used as the main basis for searches, yes. Yes,
and this note suggests that the additional checks were undertaken in respect of his Mimecast, Mr. Bradshaw's Mimecast data. Do you know why anyone was looking again at Mimecast and coming up with 942 documents last Friday?
I don't, I'm afraid.
Would you agree that just looking at the correspondence, reading the correspondence, that it doesn't make for happy reading, in that the inquiry was told back on the 19th of December that Bradshaw disclosure was complete, and then it was said that 924 documents, including lots of duplicates, were to be produced last Friday?
Absolutely. It goes back to the point really that you took me to, I think, in my initial witness statement is nobody would wish to continue to have anything other than a sort of more conventionally controlled and managed and critical path approach to hearings. And
the email that we've just read about the involvement of another company providing services to KPMG, and that being the cause of an underestimation of the number of duplicate documents. Is that anything you know about?
I know what I think it is, but I would qualify this because I'm speaking from what I would understand that
Yes.
to be, not because I know, but because I'm reading it, is and why I'm hopeful that certainly the issues around duplicates, whilst they are still difficult, will improve going into phase 5. And
Which is where,
if I may take it in two parts. I think what is being referred to, but I do not know, is the point that Paul Tombleson made when he gave evidence on the 5th, which is, and I touch on in my witness statement, which is the current relativity database has been built up effectively in layers on data that has come in from various sources at various places in different ways. So I think what is being talked about is not somebody who is a contractor to KPMG, but a previous provider to Post Office. So this is one of the reasons why some of the techniques cannot be used, the computer techniques that were talked about, because the data quality is variable. The reason I am hopeful, but I don't want to overstate it because I don't know fully about phase 5, is that there has been we for phase 5, 6 and 7 are working in a new in a different bit of the database which has had the data reprocessed into it and therefore does not suffer from the same, or at least not so many of these problems. I mean, duplicates and near duplicates, for all the reasons in 20 pages of my witness statement, are a real conundrum, but that is exacerbated if the underlying data from which they're drawn is of variable quality from various places at various times.
that conundrum's compounded if you get a series of letters and emails in the day before and the 3 days before giving different figures and assertions as to what is a duplicate and what isn't, and explanations as to whether documents are truly new or not. Would you agree? I mean, reading it, would you appear that this information, this run of correspondence, is rather chaotic?
I don't know what lies behind it, and therefore I'm loath to step in from outside and criticise, because I simply don't know. But it's, I think you used the phrase before the lunch break, suboptimal, and it is clearly that, and it must be frustrating deeply for the inquiry and for witnesses, and I suspect also for those at the other end who are trying their best to get it right.
So
but I simply don't know beyond that.
So that takes me to what assurances in relation to phase 5 and 6 you're able to give, that the kind of, sorry, that document can come down, that the kind of episode that we've seen played out in the Bradshaw correspondence, and I think, if I can say it with a degree of understatement, he's not the only witness in respect of whom it has happened. And for a period, it was every witness, every day of the week, twice on Sundays. What assurances can you give that this will not happen in relation to phase 5 and 6 witnesses?
I can give some assurances, and I'll set out, if I may, what I think they are.
Yes, thank you.
Those, I'll start with a qualification, which is deduplication and complex disclosure is ferociously difficult, and there will be glitches and we will find things because that is the nature of it. But the assurance I can give is that we will use every bit of our professional skill, and I know that Post Office is absolutely of this mind also, to reduce that to the absolute minimum that we can. The other parts of the structural assurance are that, as I say, we have the benefit of data that has been to a large extent reprocessed in terms of the material that is already in there. And as a separate and further point, the inquiry will be aware that we've on a number of in a number of letters, we've been sort of exercising our minds as to how one can square the circle between potentially excluding something which is a material difference. So the example I give is so you don't want to textually near duplicate out something that changes a shall to a shall not, for example. But equally, one does not want to be burdened at the inquiry of witnesses by things which just have minor differences in the footer or so on. So we've been giving thought to that and have written to the inquiry about additional load files, i.e. Extra data which can be used to sift into wheat and chaff, and then circle back round to look at a particular document if the inquiry wants to look at details of that. I started with a caveat, and with apology, I have to finish with this answer with a further one, which is Exchange is an email system, and therefore the transference of data is slow and difficult and clunky, and we will do, and I believe KPMG and Post Office will do all they can to eliminate that. The timescales there is a challenge between the timescales because it isn't just obviously about the start of the hearings, it is about the lead up to those hearings. All involved wish to get to a smooth procession to that. I wish I could give an unqualified assurance, but the sheer practicalities of complex disclosure, duplicates and exchange mean that I have to stay some way short of that.
In paragraph 88 of your witness statement, which is on page 77, if that can be displayed, please. Page 77. In the third line, you say Post Office started in June 2023 the exercise to identify the full extent of the Post Office's electronic data universe. Why was it that it was only in June 2023 the Post Office started the exercise to identify the full extent of its electronic data?
I don't know.
That's a couple of years into the inquiry, isn't it?
It is, yes.
Are the problems we're now facing in part caused by the Post Office only starting to identify the extent of its electronic data in June 2023?
I've commented this on paragraph 84. I wonder if it would be possible just to turn back.
Absolutely. That's the previous page, page 76.
Yes. So it picks up on the previous paragraph picks up on the work that we'd initiated in June and July, but I say, and it is absolutely the position, it would not be fair or fair inference to sort of view the structural review as an indication that things hadn't been done before. There had been, from us, we weren't around at the time, but from what we have since learned, and quite a bit of investigative work, and to find out what there was and where it was, and so and to do that work. It hadn't been done under a single overarching model, but a lot of work had been done, and you will see quite a few of the answers to that work in the first, second, third and fourth disclosure statements.
So I think you're answering to say you shouldn't think that no work had been done to identify the extent of the Post Office's data universe. Correct?
Correct. a very large amount of work had been done, but it hadn't been it had been done by various people at various times in various ways using various exercises rather than it being done as a comprehensive mapping exercise.
Which takes us to the third topic, the structural review. This is part of the structural review.
I'm sorry, what is part of the structure?
Identifying the full extent of the electronic data universe.
Yes, the model that we talked about earlier is effectively you identify, you preserve and you collect, or you collect as you need.
And you describe in paragraph 82, if we go back please to page 74, the elements of the structural review. You say it's not directed at a single phase or multiple phases, and the main activities, and you divide them into three: an exercise to identify the full extent of the data universe, to validate assessments of all data sources to whether they're reasonably likely to contain data that might be relevant to the inquiry's terms of reference, whether any such data has been preserved and, as appropriate, collected and processed for review. Secondly, the structural review involves a consolidation of relativity workspaces to reduce time and operational complexity when requests from the inquiry, when responding to requests from the inquiry. And thirdly, an exercise to validate custodian data mapping to facilitate an assessment of whether further identification work is required. Can you explain what that is, because it's not obvious on its face? Custodian data mapping.
Essentially, who would have held what type of data? But amongst those individuals or custodians who are of likely relevance to or known relevance to the inquiry.
So identify people or job positions, job titles, who are assessed to hold data.
I'm hesitating because colleagues are involved in the exact detail. I don't know whether it is named people or whether it is job titles, but we can update further.
You set out timelines in Appendix 3 to this document, your witness statement,
Yes.
but they have essentially been superseded by the third of the Tuesday letters, is that right?
That's correct.
And so can we go as our last task to the third of the Tuesday letters, poll 0033 3344. I'm going to ignore the first three paragraphs and go straight into the content. You split the letter into three strands, essentially. Strand 1, ESI, that's electronically stored information on electronic media.
Yes.
Topic 2, electronically stored information excluding e-media.
Yes.
And then thirdly, hard copy documents. So can we take those three in turn?
Yes.
Go back to page 1, please. ESI on stored on e-media. And I think this has got 4 elements to it, each of which is underneath an underlined heading.
Yes.
The first of which, element 1 of strand 1, investigation of 5 servers and 12 backup tapes located in Chesterfield. And I think it was identified by the Post Office that it had servers and backup servers in Chesterfield, and this was revealed to the inquiry in November, I think. And you set out in this letter the position server by server.
Yes.
Scanning across paragraphs 1.1 and 1.2 is the position that 3 servers have been excluded. 2 remained further to be investigated, and the 12 backup tape servers have been restored in recent days.
I'm not sure about the last point. Yes, the 3 servers have been excluded. All of these categories in this letter, for context, are, or many or most of them are at what one would ordinarily say is at the far end of what would normally be done in terms of any search in a litigation case or inquiry for good reason, given the circumstances that you outlined earlier, that then all of the corners are being searched, and this is the furthest corners, if you like. And so some of these servers, as we're seeing, are well, one doesn't know what they are when they start being examined, but they've sat in a dusty corner for many years.
So if we go over the page to paragraph 1.12, so 3 servers excluded, 2 left, 12, sorry, if we just go up, please. 12 backup tapes. The reason I said 12 backup tapes have in recent days been restored is because that's what it says in paragraph 1.11.
Yes.
And then 1.12 is where it's all brought to a head. You say we'll continue to update the inquiry on Post Office's work to examine the 2 servers and the 12 backup tapes. And then this, progressing those investigations, may take a material period, which is a delightfully enigmatic phrase. Can you tell us what it means?
Yes, it means that some very technical people who can decode things which may be 5 or 10 or 15 years old, and therefore old technologies which are no longer supported. And those are obviously backup tapes are things which are run on a server, so you don't lose the data if the server fails, and they often overwrite themselves or they duplicate, because if you're taking a record at a particular point in time, then that point in time will also contain material from earlier. So the reason I hesitated was, yes, they have been restored, but they haven't been examined. The technical people who can do this sort of thing now have to take them into another dark room and do something with them, and it's not knowable in advance how long that takes, and it's unfortunately.
So how should the inquiry plan for the commencement of phases 5 and 6?
This effectively comes back to the issue of case management and the point in the inquiry's protocol about fair and reasonable in all the circumstances. This is, there's effectively two routes, well, 3, I suspect. One is to take a view that these things are unlikely to be relevant because they are at the extreme ends of relevance.
How,
and take a view.
On what factual material could a view be formed that these 2 servers and 12 backup tapes are in the very corner of the corner that you described?
No, that has to be assumption or presumption rather than anything else. One doesn't know until one looks.
On what building blocks might you draw the inference that you have just outlined? I.e., on what firm factual foundation might a person be able to say, I'm willing to commence phases 5 and 6 or list phases 5 and 6 without any insight into when the material from these 14 data sources is likely to be available to me?
Well, if I may come back to the other 2 options as well, because they were going to tie back into this point as well. If it is possible, and I don't know technically whether it is, the starting point logically would be to look at as the first interrogation, before one looks at the content of the data, to look at the dates of it and then extrapolate from that whether it is likely to be of relevance to phases 5 and 6, because there is obviously 5 and 6 does go back in time, but not so far as, say, 5 or 2 or 3. And then secondly, if one can get an insight into the type of data, if, let's say, for example, it was financing or accounting data as opposed to documents or other evidential material that the inquiry would tend more to focus on, then that would inform you. But the basis the inquiry does not have, and Post Office does not have to give to the inquiry, those initial evidential basis blocks. But the three options would be to effectively take an assumption when knowledge builds. The second, which is the more I was setting out the two extremes, is to effectively take a long pause until everything would be held to be within the fair and reasonable search and look at everything, but that would be involve a delay.
And you wouldn't know how long the period was. You'd have to say, I'm going to adjourn for a material period.
It would be a material period, and that would be the second option. The third would be to list but effectively engage in a case management discussion as to the prioritisation of witnesses and types of information, which would itself be informed by trying to find some early stage information about type of data, dates of data, and so on. But those are the three, as I would see them.
This material, the existence of this material was revealed to the inquiry in November. How long had the Post Office known about it?
I don't know.
Can we turn to element 2, please? Confirmation of understanding relating to the NAS drive data. Can you explain in a crisp sentence or two what the NAS drive data is?
The NAS drive data was as I understand it, a capture of a particular set of data that was known about at the time or just after the GLO and prior to the 2020 work. So it was a snapshot of a very large amount of data at a point in time. What this section, sorry, you're probably going to come on to ask me about this next section, but the NAS drive, effectively was a data capture at a point of time, which from memory was 2017 or 2018. You tell us in paragraph 1.14, intended to update us before today, and you tell us in 1.15 that the Post Office is seeking to establish how long investigations are going to take. I take it today you don't know how long the investigations are going to take. I'm afraid not. The NAS drive is something that was captured and is known. What this section relates to is I think it's a server or system called either Accenture file share or more accurately Post Office file share. And there had been a couple of previous letters to the inquiry. The first one said, this has just emerged and we think the Post Office file share is something you need to know about, but we're investigating. There was a second letter that said, emerging conclusions are that it is just duplicative of NAS drive, but we need to make very, very sure. And it has not, as I understand it, been possible so far to make very sure that there was not new things going on to the Post Office file share. So the Post Office is not able to tell us how long the investigations will take. Are you able to tell us when you're going to be able to tell us how long the investigations will take? Because these are technical, not legal issues, I cannot. There is pressure, as you would understand, being applied by Post Office and by those who represent them to get it completed as soon as possible, but they're technical investigations. Bottom of the page, validation, that's the third element. I'm going to skip over that because there is a timescale included. Over the page, please, to element 4 of Strand 1. Review of custodian disclosure questionnaires to establish whether further collection of e-media is required. And then paragraph 1.18, Post Office wants to ensure the inquiry is aware of decisions Post Office has made regarding relating to the collection of data. Post Office has not identified, after investigations of users, including questionnaires that have asked custodians to provide details of their WhatsApp usage, repositories of WhatsApp messages reasonably anticipated to be responsive as substantive evidence to the inquiry's terms of reference, and completed list of issues so as not being collected from their devices. Can you just explain what that means, that very long sentence? Yes.
We haven't asked people to provide their WhatsApp usage, and we haven't looked on their phones. Is that it?
Because we have tested whether it would be needed to be done by seeing by asking them questions as to do they use WhatsApp and what do they use it for, and the responses, as I understand it, come back effectively that it's administrative. What dates are this and so not the situation as we understand it based on the questionnaires, where people will be having substantive discussions of the kind that are being canvassed in other inquiries at the moment.
And so
we understand, but if that changes, or we have a reason to believe it changes, then we would revert.
So if Paula Venables was intending to attend a meeting and was going to discuss with Angela van den Boogaard beforehand what to say and what not to say, she wouldn't have used, on your understanding, WhatsApp to do so?
Based on the information we've gathered, no, she wouldn't. They, as we understand it, there may have been liaison in terms of who's free on particular what date, but as we understand it, not substantively.
How wide or how big is the pool of people that you have asked?
I think it relates to all the key custodians, but I will verify that and we will write.
What does the key custodians mean?
Those who have been named in... the short answer is I don't know which individuals we're talking about, but certainly all those that who would have been named and who are still current employees.
So there's a limitation that the person has been it remains in post office.
I don't know, so I will check and we will come back to you.
It may be a surprise to a member of the public that nobody in the post office used WhatsApp to discuss issues of substance relating to the Horizon system.
That is our understanding, but we are keeping it under test.
Okay. Strand 2, ESI excluding e-media. This is from paragraph 2 onwards, and again there are a number of strands. Identification of, elements to the strand, identification of the extent of the data universe. 2.3, you tell us it's been commenced, and you told us in your witness statement that was back in June. It's materially progressed, but is ongoing. Several further weeks to complete this work. Does that mean by the end of the month?
Again, I don't know, because finding the information it's easier to find some information than others, so I don't know.
Element over the page, please. Element 2. We've addressed that already. Element 3, validation of historic preservation activity across other ESI data sources. Can you explain what that is, please? So this is paragraphs 211 to 215.
So this is looking back at, so the previous section deals with what is currently in place. This is looking back in time as to what was in place previously in the GLO litigation or otherwise, and we haven't been able to establish so far what technical holds were in place. We understand and we've seen what was in the interim disclosure statements, and that we're told various holds in 2014, 2016 and 2020, but the position, because of the situation in paragraph 214, is difficult. The people who did it are often not around, and the records are not therefore available, so we're still looking. The
next element, I think, element 4 within Strand 2, review of electronically stored information received in the past from third parties to establish whether further collection is required. I think if we go over the page to paragraph 2.19, in the second sentence, you tell us it's anticipated that material work will continue beyond January 24 and will continue to update the inquiry. Can you assist us as to what volume of the work will have been completed by the end of this month and what will remain outstanding?
To put it in context, this is going back to all, particularly the third-party legal advisors, but there's some other advisors in particular, to say you were asked previously to provide all key advices because that is the things that are under control. But as part of the structural review, it is not always clear, it is not clear to us as incoming advisors what was provided. So we've said what effectively looking at what have you given us, what have you not given us, and then testing what we have been given. So we're working steadily through the different advisors. I don't know precisely where we've got to. Obviously, it depends on when they come back to us as well and when it was asked. But it's all of these things we're trying to retrofit an understanding, and it's a ongoing process.
Hard copy documents is Strand 3. Can you help us overall what is outstanding?
Can I just look at the paragraph? These are exercises that we didn't and don't have conduct of, so we're reporting effectively this was the work done by Innovo, as I understand it, but I'm taking this from the Innovo witness statements that were submitted to the inquiry. Their work on hard copy has been completed, and as has the re-indexing.
It seems like a third task is outstanding, which is looking back at questionnaires to see whether hard copy documents require to be collected from other repositories.
And again, it's not something that we're doing, but we are told that it will be complete by the end of the month.
Thank you very much. Mr. Jackson, they're the only questions I ask you. Thank you very much.
Thank you. So
there are no questions from core participants in particular, because we said that all questioning of Mr. Jackson, as in previous disclosure hearings, would be conducted by counsel to the inquiry.
Yeah. Well, first of all, Mr. Jackson, thank you very much for your detailed written evidence. And thank you very much for the clarity of the answers you've given to Mr. Beer during the course of the day. As is my custom following hearings of this type, I don't make instant announcements, that being fraught with danger. Rather, I propose to reflect upon what's being said, and anything that I regard as important to say, I will say in the course of the coming days or weeks in writing, and any further directions which I propose to give relating to disclosure will be contained within that same written statement. Clearly, I want to reflect upon the state of affairs which you describe, where there are options, if I can put it in that way, as to how best to proceed. So that's as much as I propose to say today. And that brings us to the end of today's proceedings, does it not, Mr. Beer?
It does. We're back at 10 a.m. on Tuesday, sir.
Okay, thank you, sir.
We're adjourned until then.
Thank you very much, sir.